Affidavit.
Affidavit.
First of all, I want to thank Justice John Manglona, who's joining us from Saipan, sitting as a Justice Pro Tem. Will the clerk please call the case?
This is Supreme Court case number CRQ23-001, Lourdes A. Leon Guerrero, Imagahagan Guahan, relative to the validity and enforceability of public law number 20-124. Appearing for Petitioner Governor Leon Guerrero are attorneys Leslie Travis and Jeffrey Moots. Appearing for Respondent Attorney General of Guam are Attorney General Douglas Moylan and Attorney Marianne Woloshuk. Appearing for Legislature Guahan is Attorney Michael Phillips. Appearing for Amicus Curiae William S. Freeman, ND et al. Are attorneys Anita Areola and Vanessa Williams. Appearing for Amicus Curiae Robert Klitsky are attorneys Braddock Huseman and Deborah Fisher. Appearing pro se Amicus Curiae is Timothy Rohr. Panel members consist of Chief Justice Robert J. Torres, Justice F. Philip Carbolito, and Justice John A. Manglona. Your Honor, Attorney Travis reserves 10 minutes.
You may proceed, Ms. Travis.
May I have a moment, Your Honor? Good morning, Your Honors. Chief Justice Torres, Justices Carbolito and Manglona. May it please the court. Approximately 1 year ago, the U.S. Supreme Court issued Dobbs versus Jackson Women's Health, a decision overturning the 1973 landmark case Roe versus Wade, where Roe required states to tailor abortion laws according to stages of pregnancy and interests involved to ensure affected individuals the right to privacy guaranteed in the 14th Amendment to the U.S. Constitution. Dobbs removed these requirements, holding that the Constitution does not guarantee the right to terminate a pregnancy. As in many other jurisdictions across the nation, this court is asked today to interpret our own constituting document, the Organic Act of Guam, to determine whether and how an abortion ban that the Guam legislature passed over 30 years ago, and which was held to be unconstitutional and inorganic 30 years ago, has any place in Guam today. On behalf of Lourdes Leon Guerrero, the governor of Guam, I submit that it does not, for two reasons. First, unlike other jurisdictions, the Guam legislature then and now has no authority to pass inorganic laws. And second, the laws of Guam passed since 1990 authorize abortions in certain circumstances and have therefore impliedly repealed the sweeping 1990 abortion ban.
Before we get into the discussion of the merits, Amicus Klitsky has argued that because the governor can't demonstrate that she suffered an injury in fact, and if Article 3 standing applies to this case, the case should be dismissed for lack of jurisdiction.
Your Honor, I will address Amicus Klitsky's arguments more broadly, but to address the question before that Your Honor has posed specifically regarding whether or not the governor has an injury in fact, I will note that in footnote 4 to the airport case, that's in Re AB Juan Pat Leon Guerrero, Juan Pat Airport, the court actually recognized that 4104 cases elevate otherwise intangible harms posed to the governor to the status of an injury in fact for purposes of Article 3 standing. However, moving more broadly to the questions that have been posed by Amicus Robert Klitsky, as the court recognized in the airport case, like other non-federal courts, it's not governed by Article 3. This is not an Article 3 court. The courts of Guam are not Article 3 courts. and it is therefore not required to apply federal constitutional standing requirements. I believe we're all in agreement there, including Amicus Curiae. But the court has adopted constitutional standing standards, including the controlling federal test that was articulated in Lujan versus Defenders of Wildlife. And this is where Amicus Curiae diverges with the court. Amicus Curiae argues that constitutional standing should not bar an action in the courts where standing has been conferred by statute. But because the court has broadly accepted constitutional standing, he argues that it should be applied rigidly, or as Amicus Curiae puts it, it's a blunt instrument that should be applied in every case in every court on Guam. I would submit to your honors that this is actually a backdoor attempt to try to get the court to throw out constitutional standing as a whole. Effectively, it's a collateral attack on the airport case and its progeny, but this argument must fail. The fact is that a majority of courts, a vast majority of courts, have self-imposed some version of constitutional standing for different reasons. Some courts, like Illinois, use it to cull their dockets. Other courts, like Nevada, for them, it's based on a history of requiring a justiciable controversy as a predicate to judicial relief. And for still other courts, like Kentucky, it's based on a prohibition against generalized grievances as a fundamental principle of adjudication. About half of those states have adopted the Lujan test, as this court has. And a substantial majority of states don't attribute their adoption of constitutional standing to the text of their state constitutions. And some courts even acknowledge that their constitutions don't contain comparable language to Article 3. Most states also recognize exceptions to constitutional standing, most notably in matters of great public importance or great public interest. Though Amicus Curiae argues that adoption of the federal standing doctrine means an unyielding, uniform standard, including in 4104 matters, objectively, across the nation, that's just not the case. This court has in fact already recognized that it has jurisdiction over 4104 actions, notwithstanding the absence of a case or controversy.
The criticism, as I understand, that Attorney Curiae brings out is that the airport case lacks an explanation as to the source of its authority for adopting when it adopted the Article 3 standing. That although, as you very articulately point out, that Article 3 standing is the state courts are not required to abide by that. But in the airport case, we did articulate that in every case that they must satisfy the three-part test in reference to Article 3 standing. But I think, and there is substance to this argument in my mind, is that the court did not articulate the basis for that, and especially as is explained, where there is other language in the Organic Act that gives the legislature the authority to specify the jurisdiction of this court. So how is it that we can clarify, and you started to describe how other jurisdictions who also don't have the case or controversy language within their constitution have not hesitated to adopt the three-part constitutional standing test. So how is it that we clarify that? What is the basis of our authority in which to require Article 3 standing in our jurisdiction, and that's really from case law rather than any requirement of statute?
Your Honor, actually, some of the courts, one of which I referenced, which is Nevada, have actually referenced a long-standing tradition in their jurisprudence, in their jurisdiction, of recognizing Article 3 standing requirements, or similar to Article 3.
I understand that they just recognize, but what is the basis for their recognition? What is the principle of law in which we can look at and so that that we may not be so we don't open ourselves up to the same criticism that we have not articulated the basis of why we feel that we have the power and the authority in light of the languages in the Organic Act in which what is the basis for our authority.
Your Honor, in response to that, I will say that I believe that the court has the authority to do it. However, I will disagree respectfully, Your Honor, with Your Honor's statement earlier that there's no basis in the Organic Act for a case or controversy determination. And if Your Honor,
there is no language that says that we are confined to addressing cases before our court only that provides case or controversies like the federal Constitution. Let's cut to the chase here. A lot of the jurisdictions that and ones also that you have pointed out point to the separation of powers doctrine, which is something that we do have in our Organic Act. We have language that provides for 3 co-equal branches of government, and some of those other jurisdictions look to that language and see an implied power based on the separation of powers, in which this court should stay in its lane in reference to addressing the type of cases that come before this court. So is that something that we can base our authority on in reference to requiring the 3-part constitutional standing requirement in our courts?
Your Honor, I think so. The separation of powers doctrine actually underlies the case or controversy line of cases in the U.S. Supreme Court. The point of it is that the court wants to decrease its footprint essentially in the federal government. So it's not addressing advisory opinions, or it's not addressing opinions that are frankly just not ready to be determined in a court of law. I do think, however, as I started to say earlier, Your Honor, that while that is, I think, ample grounds for the court to determine that it can apply or it can adopt a case or controversy standard, I think that the Organic Act does actually provide a path for the court applying case or controversy in lower courts. And if I may, Your Honor.
Well, let me just go one step further, because Mr. Klitsky says that number one, there is no articulation. But number two, even if there is this requirement as announced in the airport case, in this particular case, Governor Leon Guerrero has not articulated any injury in fact in reference to satisfying the first element of the 3-part test, that there is, because of the injunction that currently exists in the law, there is no threat that this statute is going to be enforced. And so she has failed to articulate an injury in fact, and therefore she has no standing to bring this lawsuit before the courts today.
Your Honor, with regard to whether or not the governor has articulated an injury in fact, the court has held in the Ken Leon Guerrero matter that as long as you meet the standard that's provided in the legislation that grants the cause of action, that you do in fact meet the injury in fact requirement. And as the court recognized in the airport case, 4104 actually does elevate the intangible harm to the governor to an injury in fact. And one of the standards that's provided in 4104, Your Honor, as Your Honor's recognized in order number 2, was that there's an undue delay. There's a potential for undue delay in the federal court's resolution of the issues that are before Your Honors in this case. In fact, it was on that basis that the court eliminated the first question, if Your Honors recall, because in that question, you determined that in fact, notwithstanding the pending injunction in the district court, that it can in fact be addressed there on the path to the court's resolution of the Attorney General's motion to vacate that injunction.
Your response raises many questions and issues, but just going to the heart of this, and not focusing on whether the legislature has those prescribed powers to specify the injury. If, again, going back and setting aside whether or not the legislature can prescribe by statute, which you seeming to argue is the injury, assuming that the governor cannot show any injury in fact, as that test is articulated, you reference this great public purpose provision that is, number one, contained in 4104, but that does not prescribe an injury. That, to me, prescribes an exception to the injury. And so, is that something that we can look at?
Of course. In most courts, Your Honor, that have articulated Article 3 standing, they do in fact recognize exceptions. Even the US Supreme Court has recognized an exception to Article 3 standing. However, in the state courts that have adopted Article 3 standing, they almost always have exceptions, and the most popular exception is a matter of great public importance. The second most popular exception is taxpayer standing.
Would that, recognizing those exceptions, would we have to revisit the airport case? Does that, Mr. Klitsky argues that if we were going to deviate from the strict constitutional three-part test, that we would then have to either say that the governor doesn't have standing because she has not been able to show an injury in fact, or that we need to overrule the airport case.
Your Honor, I don't believe it's overruling it. I think it's refining it. As I argued in the governor's brief, in the reply brief, the cases that have so far been before the courts have been adversarial cases raised at the lower court and then appealed to the Supreme Court. It's never been with regard to the 4104 action that's brought for this court's original jurisdiction. And I do think that there's an Organic Act distinction between this court's original jurisdiction and the lower court's original jurisdiction. I think that
Counsel,
is the Organic Act.
Counsel, going back to Mr. Klitsky, he discusses three options. One of them is stare decisis, and now you're discussing whether we should overrule airport and Leon Guerrero. And the other one is, of course, the 4104 carving out. Which do you espouse? Obviously, you don't espouse the first option of stare decisis, but what about number 2 and number 3 from just Mr. Klitsky's discussions?
Justice Manglona, I do believe that the court has authority to carve an exception for matters of great public importance, as has been done in jurisdictions across the country that have adopted Article 3 standing. As I started to say, Your Honors, the Organic Act does distinguish between the jurisdiction of this court in its original jurisdiction and the jurisdiction for other courts in Guam. There's this cause language. 1424 1D provides that local courts shall have original and appellate jurisdiction over all causes in Guam. 1424 1A2 likewise provides that this court shall have jurisdiction to hear appeals over all causes in Guam. 1424, which describes the District Court of Guam's jurisdiction, also provides that it has jurisdiction in all other causes in Guam, jurisdiction over which is not vested in other courts. In contrast to these three jurisdictional provisions, this court's original jurisdiction is not so limited. 1424 1A1 provides that the Supreme Court of Guam shall have original jurisdiction over proceedings necessary to protect its appellate jurisdiction and supervisory authority, and such other original jurisdiction as the laws of Guam may provide. I submit that this is broader than the cause language that's provided in lower courts. And the US Supreme Court itself actually contemplates in Hone versus US 524 US 236 that the words case and cause are synonyms in statutes, each
But
meaning
you
a proceeding in
You
court.
seem to conflate cause of action with injury in fact standing. And you're saying that if there, in here, the legislature has provided a cause of action and allowing the governor or the legislature to, if they satisfy the three elements, 3 or 4 elements under the statute that must be satisfied, that automatically they have satisfied the standing requirement in this particular case, that they are the injury in fact requirement. I'm not so clear or sure that that is the same thing.
Your Honor, the distinction that I'm actually making is that the language cause that's provided for the lower court's jurisdiction is case and controversy for purposes of Article 3 standing, because cause and case mean the same.
And I don't quibble with that. I think the argument that then in response to that is that there still must be a satisfaction of an injury in fact, which Mr. Klitsky has stated in his briefs as not articulated in this case. And I guess the question to you is, what is the injury, if any, and if the governor is not able to specify a specific injury because there's an injunction, there's no threat of the enforcement of this public law, then how is it that the governor can come in and continue this case in our courts?
The court in the Ken Leon Guerrero case, in considering taxpayer standing, actually found that the intangible or the nebulous injuries that a person might suffer are elevated once the legislature actually confirms a cause of standing pursuant to its Organic Act power. At that point in time, as long as you meet the criteria, in that case, it was taxpayer standing, a resident of Guam, and a request for a particular remedy that the court found Ken Leon Guerrero did not allege in his.
So the bottom line in your argument is that even if the governor can't show injury, this court has the authority to create exceptions to constitutional standing. And you pointed out the great public interests or provision that this case brings, and that 401 statute was passed by the legislature.
Yes, Your Honor. And in fact, the court already recognizes that in 4104 matters, that is the case, that does actually elevate it to an injury in fact.
Didn't we rule on the quarantine case in a 4104 matter post airport?
Yes, Your Honor. That was in 2021.
Ms. Travis, it seems like the governor and the attorney general who was representing the governor in 2001, this is the Init case, and also the request of Gutierrez, the governor through the AG took opposite positions, and that one says we have jurisdiction, the other says we do not. So what is the stance now is, yes, we have jurisdiction.
Yes, Your Honor, although it appears as though the Attorney General has joined with Amicus Klitsky's position. So we are on opposite sides of this particular argument, but I would submit that, yes, the court does have jurisdiction. And
yes, and it is the same Attorney General who represented the legislature back 21 and 22 years ago with the opposite.
I think that's correct, Your Honor.
Let's go now to the substance and the argument that the law is void ab initio and the legislature acted ultra virus in passing a law. You make an argument that Public Law 20-134 is inorganic, notwithstanding the issuance of Dobbs. And I don't think any party is arguing that the courts can't prevent enforcement of laws that violate the Organic Act of the Constitution, but it's a wholly different claim to say that the legislature lacked the power to pass 2134 in the first instance.
That's correct, Your Honor. 20-134 was passed during a time when the court did, when the legislature did not have authority, because the law of the land at that time was Roe versus Wade, which was the prevailing interpretation of the 14th Amendment, which applied to Guam in two different ways. One, because the 14th Amendment was incorporated into the Guam Bill of Rights itself, the text of it, and also through the last the last provision that actually conferred the same protections of the 14th Amendment, subsection U. So because the law of the land at the time was Roe versus Wade, and that interpreted the 14th Amendment to require that the legislature conform to particular standards in adopting any legislation with regard to abortion, the legislature violated the Organic Act provision that limited its authority to laws that were constitutional and organic only. And its failure to do that is a substantive failure. It doesn't just make that law unconstitutional, it makes it inorganic. And what that means, Your Honor, is it's not a zombie law. It cannot be revived in the future when there's a change, because it affects their authority to pass a law in the first place, not just the substance of whether or not the policy decision underlying that.
But what if the legislature was, let's say, instead of the Mississippi court that was acting in Dobbs, it was the Guam legislature that acted. So at the time that it passed that statute, it was unconstitutional under the prevailing US Supreme Court authority, but then worked its way through the courts and ultimately determined that the law was constitutional. How could we say that it was void ab initio when at that time it was against the prevailing authority, but subsequently determined that it was not?
Because in that case, the final adjudication would occur in the Supreme Court. Here, the Supreme Court, in fact, denied cert over the Ninth Circuit's determination that this was unconstitutional and inorganic law. So it was finally adjudicated to have violated the Constitution and the Organic Act. If the legislature had appeared instead of Mississippi and Dobbs, it would have gone all the way to the Supreme Court and the final adjudication would have vindicated it. It would not have been held unconstitutional and inorganic.
So it wouldn't have been void ab initio.
It wouldn't have been void ab initio because the final adjudication would have been that it was consistent with the Constitution, if it had gone up to the US Supreme Court and that was the determination. However, the final adjudication in 1990, which is when the test needs to be applied, it has to be applied as of the time of enactment. 50 years later doesn't go back into 1990 and give that legislature authority where it didn't have it in the first place. It'd be different if the 37th legislature of Guam passed a law like this, maybe, but certainly the fact that Dobbs was issued a year ago doesn't change the fact that the 1990 legislature had no authority to pass the law.
I note that you only have 4 minutes remaining, and I know you reserved 10.
Can I
Go
just
ahead.
ask, Mr. Chief Justice, so if the court agrees with your interpretation that the statute is unconstitutional, the legislature did not have the power to enact in light of Roe v. Wade, and we announce our decision and agree with you, what does that do with whatever is pending out there? I mean, you know, I like to think that our decision would be respected and whatever the decision is. And so I'm just wanting to be a little more informed as to the practical consequences of our decision.
Your Honor, if you're referring to the district court case and what's pending in that action, the district court case, I actually moved for an abstention in that case under Pullman because of the local questions that need to be resolved by this court. And so for matters of local law, obviously this court is going to be the court of last resort, and the district court would be required under federal case law to honor this court's decision with regard to local law.
Has there been any decision in response to your motion?
No, because the court actually on another motion, because the Attorney General, the court found that the Attorney General did not address certain issues in an opposition brief. The court on procedural grounds determined that the Attorney General didn't meet the standard under 60B for a motion to vacate injunction. So
Well,
that
then-
is actually pending appeal in the Ninth Circuit right now.
Well, that may be true on the issue of whether there's been a repeal by implication by the subsequently passed law, because it's truly a local law. I'm not so certain that the interpretation of 48 USC 1423A on the legislative power of Guam extending to all the legislation not inconsistent with the provision of the Organic Act or the laws of the United States applicable to Guam wouldn't also be subject to a federal interpretation?
Your Honor, I think that that's actually, I think that that's a great question. In the Lim Tiaco case in the U.S. Supreme Court, the Lim Tiaco case actually, the court observed there that on matters that are not purely of local concern, that the Supreme Court, that the Supreme Court of Guam's opinion is entitled to respect, but not deference. Here, I think that there's a valid question of whether or not this matter, this determination by the court with regard to the ultra-virus question, whether or not that actually constitutes a matter of local concern. And if it does, Your Honor, which I submit that it doesn't really affect any other jurisdiction outside of Guam, I think that this is the court to make that determination. I don't think that the District Court of Guam or the federal courts are the best courts. Maybe they're an appropriate court because it is a federal statute, but it's the Organic Act of Guam and it's our interpretation of that. So I think that this court's decision as the court of last resort in Guam is entitled to deference under Lim Tiaco.
Ms. Travis, I have, going back to the earlier discussion of undue delay, which is the second factor in 4104. What is the status in the Ninth Circuit, and is there really an undue delay on this particular issue?
Yes, Justice Mangualina, this issue is not actually pending. Currently, there's multiple motions that are pending in the district court action that are in abeyance until the Ninth Circuit resolves the motion to vacate that has been filed by the Attorney General. The status of that, I believe, is that the Attorney General's brief is due on July 28th. And then it's just going to go through the briefing schedule after that. But this issue is not, while that motion is pending, I do still have a motion for abstention that also needs to be resolved in the district court. So it's difficult at this point to predict, Your Honor, whether or not resolution of the Ninth Circuit matter would actually hasten a decision on the issues before the court here.
If I may just ask one more question, please. I know
Sure.
Time is up, but if the provisions or the language of 134 is adopted, or there's a law that uses that language, passed, would it be constitutional? All the provisions in 134?
It would not, Your Honor. And I actually addressed this in the opening brief and in the reply brief. The Attorney General didn't appeal the district court's decision with regard to sections 4 and 5. This is the prohibition on solicitation of abortion services, which of course that law is unconstitutional with regard to the First Amendment, and there's U.S. Supreme Court authority in Bigelow that actually demonstrates that is still, it's still good law. It hasn't been overturned by Dobbs. The prohibition on solicitation, which includes, for example, encouragement of an abortion, that's still good law. The Attorney General didn't appeal that to the Ninth Circuit. That was never pending. That I think if 134 were passed today, those provisions would still be unconstitutional pursuant to the Ninth Circuit decision.
Okay, thank you.
All right, thank you. I know that you're out of time, but the court will give you 4 minutes on rebuttal.
Thank you, Your Honor.
All right. Mr. Attorney General.
Chief Justice, may it please the court. This case is more than the abortion case in Public Law 20-134. This case involves the Organic Act. This case involves the process of justice. This case involves what to do in a situation where the judiciary has acknowledged that it has made an egregious wrong from the start. unlike the opposing briefs in this case, the governor's briefs in this case, the question of constitutionality and unconstitutionality is a loaded question. The question about an implied repeal is a loaded question because those concepts are, for purposes of constitutionality, decided by the judiciary. Nobody knows what is constitutional or unconstitutional when it comes out of the legislature. It's up to the judiciary after case or controversy and adjudication to decide what is the law of the land.
But I'm a little, it's not clear to me what you mean by that statement. I fully agree that here in our territory, ultimately, any legal question challenged, we will have next to the final say, subject to a petition for cert to the U.S. Supreme Court. But in the whole process of making laws, there are opportunities to weigh in, and it's not only the courts that make the determination. For example, you, the Attorney General, you are looked upon when they ask for legal opinions to weigh in at that particular time as to a position, whether or not it's constitutional or not. You have done that, I'm sure, and you will continue to do that. So it is not only for the courts, it's not only our responsibility in reference to announcing a particular position on a law. I mean, ultimately, we may, if it's brought before us, but members of the legislature, when they take a position, also are informed as to the legality of a position that they may choose to follow it or decide otherwise. And so is your office.
The danger, Justice, is that we're all opinions until such time as it comes before the court system under our system of government. The separation of powers requirement is that the legislature, after due deliberation, come out with a majority vote to decide upon a piece of legislation, and that legislation goes to the governor for further action. The test of the constitutionality can be debated. My opinion is just an opinion. I'm just the one attorney of many. The legislature has its own legislative council that gives their opinion, but nothing can be enforced until such time as that statute is challenged and tested in the Supreme Court of Guam.
But I don't think that's the case. I mean, and there are many statutes when they are first passed by the legislature and signed by the governor that get implemented, and it may be challenged later on, which may affect its viability. But in the meantime, it continues to be enforced.
In the governor's argument, they're attempting to say void ab initio, which means that at the time that the legislature is debating a particular legislation, that somebody should go in and say, you can't do it because it's unconstitutional. In fact, 20-134 is the perfect example. In 1990, when they debated and passed that law, Roe versus Wade existed. That was supposedly the land of the law of the land in the United States. But 30 years later, it was reversed. But our judicial process was such that an injunction can be reconsidered and lifted because the legislature had acted. We take the opposite analysis on it. If the legislature was not to pass a statute because it said it was unconstitutional, then it could never be tested in the courts. It's like the chicken before the egg argument, that you have a determination of unconstitutionality before the courts say it's unconstitutional. And that's why I say, for instance, the most recent bill on the charter schools, the governor had the governor's opinion, the attorney general had the attorney general's opinion, and then the legislature decided that they wish to override and pass that. Well, the law cannot be determined constitutional or unconstitutional until the Supreme Court arguably was to review that question, or the judiciary for that matter.
I'm having some difficulty understanding the argument that you make that if we declared a law to be ultra virus, that we would be appending the traditional judicial process, and that there would be a prejudgment of the law if we declared the acts of the legislature to be ultra virus.
Thank you, Chief Justice. This is after it goes through the judicial process, and that's why I say it must clear the legislature first in form of a law, and then come to the judiciary to go through the process. If I'm understanding the question correctly, if the judiciary was to say, like it did with Roe versus Wade, that law is unconstitutional or it's outside your authority, I guess, you're not only having the judiciary have power over the legislative branch, but not living up to the equal branch of government concept, the separate but equal branch of government concept. And I would also note, Your Honors, that in our Organic Act, which is a federal statute, obviously, the legislature was the only branch that was created locally for the government of Guam in 1950. The judiciary vested with the district court, and the legislature was to decide if there was a superior court. And over the evolution of time, then the elected governor in the 1970s and the judiciary most recently, creating the Supreme Court and its own place in the Organic Act. But if the judiciary says that it's ultra vires to pass a particular statute, with respect, we feel that that is a usurpation of the equal branch of government, where there's a predetermination that a legal issue cannot be passed by the legislature, like what they did in the 1990s with 20-134, and many other states did the same thing. They waited until a decision like Dobbs, which was the judicial evolution of a legal concept. So the process eventually said we were wrong back in 1973, I believe, and then vacated that decision and left it to the local legislatures. But our legislature did pass a valid law in 1990, according to the Supreme Court Dobbs decision. And the people have been deprived of that law because of the injunction that was placed.
But Ms. Travis argues that when you examine the constitutionality of the law, it's at the time that the law is passed. You can't look at it 50 years later with a change in the law. And at the time that it was passed, Roe v. Wade was the law of the land and did not permit the abortions that were authorized by Public Law 20-134.
Dobbs is unprecedented in what had happened in the judiciary. I respectfully submit. To have the Supreme Court say that there was an egregious wrong that was committed by the federal judiciary, and then to give it back to the legislatures, the people to decide, I think is in itself a recognition of human fallibility, of the fallibility that is associated with the different branches of government, and gives the ability to respect the legislative branch at the time that it passes these pieces of legislation. It would be like the freedom of speech, where you have a prior restraint and saying you cannot say this. That's frowned upon by the judiciary's interpretation of the free speech clause. And here, the judiciary would be saying to the legislature, you shall not speak, you shall not raise your hands, and you shall not pass a statute like this. And again, it's saying that the judiciary is above the legislature by imposing a restriction on one of its most fundamental powers, which is to pass a statute, other ones being the power of appropriation, the power of oversight. It's fundamental to
I really don't understand that. I mean, there needs to be a system and process with structure and organization. If at the time, in this particular case in 1990, when the courts looked at the validity of Public Law 1, the statute at issue here, and Roe v. Wade was the law of the land, and it was struck down. And 50 years later, Roe v. Wade is reversed. To me, the remedy is quite simple. Go back to the legislature and pass the law consistent with Dobbs. Don't go back and now question the wisdom of the legislature, the courts, government back when there was a different set of rules. We address and articulate and make decisions based on the existing statutes at the time. And if it changes at a later date, then there is a process in which it can be followed.
And just as I guess the entire United States is debating that question right now, working its way through the different courts in the land, where you're having that revival issue come up, you're having that.
But those are different facts. There are trigger laws that may be at issue, where a statute has been struck down and has been rendered unconstitutional and unenforceable. And if there is now a different law that says that is no longer the case, then the remedy is to go through the governmental process.
I guess we have a different framework in analyzing what had occurred. And I, with all due respect, I respect what you're saying, and I understand from whence you're coming. It's like, instead of just issuing an injunction, the district court should have ripped up that piece of paper and said, don't ever do that again. That sort of thing, as opposed to the way that the process worked, where we will put an injunction on that statute, but they didn't tell the legislature, don't ever try to pass another statute like that. And in a way, what do you do when the judiciary makes a mistake?
Well, the district court also back in 1990 found that sections 4 and 5 of Public Law 2134 violated the First Amendment. The Dobbs decision doesn't seem to impact that separate finding that it violates the First Amendment. The focus was on the 14th Amendment. So how does that necessarily suggest that Public Law 2134 doesn't remain inorganic or unconstitutional?
First of all, my reading on that appeared to be a bit of the dicta of Judge Munson when he had mentioned it. But at the same time, there is a severability provision within our statutes under 1 GCA that would save any perceived illegality or unconstitutionality of a violation of the First Amendment. So severing that part on the counseling could be done under a severability clause. But the injunction that was brought in the district court was actually the motion to vacate that was brought in the district court was a complete request to vacate the entire injunction. And that's how the district court judge had approached it. So I would respectfully submit that although the Public Law 2134 doesn't have a severability within it, Guam law already provides that that be severed from the statute if it is the determination of the district court that that was unconstitutional in violation of the fourth.
But then how could you harmonize if you're arguing the severability under 2134? How can you harmonize that provision with the other subsequent statutes, particularly those that relate to consent or to DPHS's involvement and counseling, because it seems to violate those provisions of that statute.
Justices, unlike the cases that have been presented to this court, you do not have a case where there was a statute that was passed first in time and was found unconstitutional, and then an analysis of those 4 statutes that were passed after. This is a case where usually you have all 5 statutes in front of you and you're trying to reconcile what a later legislature did. In this case, the legislatures after the 20th Guam legislature fully were aware that they couldn't pass another one, otherwise it would be struck by the judiciary. The 20-134 was struck. So every legislature, 21st, 22nd, 23rd, and so forth, Guam legislatures knew that they couldn't do that. And all of the 4 statutes are expressly restricting an act. They're not saying abortions are legal on Guam. They're expressly saying we can't outlaw abortions, but we're going to do everything we can to slow it down, to stop it, to do as much as they can do to, like with the parental consent for minors and so forth, to interfere with the final decision to make an abortion.
But there's no legislative comment or history to support that contention that they were passing those statutes in an attempt to restrict abortion as much as possible without violating the injunction.
Yes, I wouldn't say that there's a legislative statement on it, but I would say that it's clear from the legal paperwork And from the importance of the entire abortion issue, everybody knew that in 1990, that Public Law 2134 was struck. So it would be a exercise in futility to try to pass another statute. So therefore, the legislature, again, the opposite end of it isn't the legislature says abortions are now legal. They said they did things to restrict it. Essentially, the 4 statutes passed after were all restrictive of the act of an abortion, and which is consistent with other jurisdictions in their attempts to stop abortion in light of Roe versus Wade.
What, Attorney General, but I guess there's no such express language, of course, in the subsequent legislations, but I think from when I read the statutes, it's just the legislature wants the patient or the mother to be well informed, not really to restrict abortion in furtherance of 2134.
Thank you, Justice. I will just leave it to the interpreter's viewpoint that when you stand in the way of a minor attempting to get an abortion, it is and requiring the parental consent. Otherwise, you can't get one. That is an act of stopping the act of the abortion. The Public Law 22-130 was a mandatory reporting of abortions, which would make it more inconvenient for people to quietly get an abortion. Public Law 29-115 was the ban on partial birth abortion. Public Law 31-155 was that parental consent requirement. And then Public Law 31-235 was requiring a woman's informed consent for the abortions. I cannot say more than just the act of what was passed is not making abortion legal, but is creating obstacles to having a free, quiet, and unreviewed type of an abortion procedure.
In the district court case, didn't you argue that Public Law 2134 conflicted with the subsequently enacted legislation?
No, we didn't. I did not take that position. Our position was that the injunction, because of Dobbs, had to be lifted by the federal courts. And we envisioned that the implied repeal and the void ab initio arguments would be brought by separate lawsuits. It was the governor who raised that in their briefs, and then the district court adopted those arguments in its March 24th decision. We did not take that position. We were just following the Dobbs to have the federal judiciary remove itself from the abortion question.
One of the arguments you raised was the speech and debate clause that prevents the court from declaring Public Law 2134 ultra virus. I'm trying to understand how the speech and debate clause is relevant to this issue.
To go for the judiciary to issue an order to say to the senators that you shall not pass an unconstitutional statute, I would, with due respect, Your Honor, say that that is an interference with that speech or debate. The session that occurs with the legislature.
But we're not telling them at the time they're engaged in that speech and debate that they can't pass that statute. We're examining the statute after it's been passed by them and determining whether it's valid or whether it is in contravention of the power that's provided to the legislature under 1423A.
Correct. That goes back to what I had originally said. The process is more important than this public law. The process was the legislature acts, it passes a law, and then it's out of the legislative realm. There's no more speech or debate involved. Then somebody decides to challenge it. They get the lawyers, they create the legal argument, the case or controversy, and then they file it in the Superior Court, the District Court of Guam, and the judicial process takes it from there and decides whether it's constitutional or non-constitutional. That is the essence of what I am attempting to say.
But isn't that what happened here? There was a declaration that the laws was unconstitutional. And now what we're being asked to decide is when they declared that law to be unconstitutional, was it were they acting outside the legislative power extended to them by the Organic Act when they did pass that law?
Exactly. That's what happened in 1990. It was affirmed by the Ninth Circuit in 1992. And then the judiciary said, oops, we made a mistake. And that's why the question of whether or not the law in 1990, according to the Dobbs decision, was a good law, according to the Dobbs decision. So is it the remedy to go back and say, oops, we made a mistake, everybody forget about it, for that unique group of senators that back in the 20th Guam legislature decided to pass something? Or is it more appropriate, because of the respect of the process, that you give the weight that that law is due, let it continue, let it be challenged again? And what happens if 10 years from now, Dobbs is reversed again? This is the change that's occurring in the judiciary.
But why doesn't it make more sense, as Justice Carbolito pointed out, that the legislature now, with the edict of Dobbs, go back and make and pass a law that conforms? Because there are problems with the law, even as it exists, even with Dobbs. I mean, you have the sections 4 and 5 of the law, which appear to create First Amendment issues.
Because it takes away from the public, the people, the right to have that group of senators pass a law and for them to receive the benefit. Every legislature is different. Every makeup and every issues that they decide is different. The question could be put on its opposite. Let Public Law 2134 come into effect because there was nothing wrong with it at the time, and then let our current legislature repeal it.
You know, Mr. Attorney General, I mean, your suggestions of how the process should work, we would never have finality of judgments if we were going to constantly resurrect statutes that earlier have been declared unconstitutional, unenforceable, and stricken from the books. And if there is a different set of rules that now apply, that we can now revive what had been stricken before, people will not be able to rely on finality of judgments.
I 100% agree with you, but it's the fallibility. Dobbs proved to us that what we thought was a hard and fast law of this country for 50 years was not. It was not. They clearly said they made an error. The judiciary made an error. So what do you do? It's like you're saying.
Well, the judiciary may have erred in reference to the law as viewed 50 years later, but I just don't see that the remedy is to then resurrect something that has been stricken. Go through the process again. You are advocating here that there is a process in which government operates, and that process is if a law has been stricken and you wish to bring it back, you go back to the legislature.
But what do you do when the legislature passed a valid law? You can never get that legislature back.
Then you go back to the legislature and correct it.
It's not the same people that were there 30 years ago that passed that law. That's you deprive.
But the law wasn't the same 30 years ago either.
The law was, at least according to our Guam legislature, said that there shall be no abortions on Guam. Had Dobbs existed at that time, that would have been the law, and then there would have been an election to finalize it. So
you're saying that the remedy is to recreate the rules, circumstances that should have existed in 1990, and in some way recognize what should have been done in 1990 because of a different set of rules that apply today. There's so much uncertainty in that, Mr. Attorney General.
That is what the judiciary did themselves. They created the judiciary. They created the uncertainty because they said the law back in 1990, back in 1973, was abortions are legal.
But that's the finality of that had to do with the issue of abortion. But that is not what is before us. What is before us is power, the power of the legislature, the power of the courts, and the announcement of how that is applied in reference to the language in the Organic Act. It has nothing to do with the issue of abortion.
And this is why I say the process is more important than the issue of abortion. Dobbs created they uprooted the finality that we're discussing here. After 50 years, they says, oops, we were wrong. But as justices are aware, laws on our books have been ever since 1950 and so forth. But I mean, what do you do to respect the judiciary, the legislature at the time that a law was passed when the judiciary has made a mistake? Is it to just say, oops, we made a mistake and try to forget it? Or is it to give the legislature the due regard that the Organic Act said that they did pass a valid law?
Well, to me, you pay proper recognition to the legislature if the rules have changed to say that now you can pass a statute that you determined 30 years earlier should have been passed, and that it would be recognized as a lawful and valid.
And that is where I say that the facts and circumstances of this case and what the US Supreme Court did have created a whole new ground for interpretation on what the legislature's power at the time was, what you do when the judiciary has erred, and the subsequent statutes that were passed after that. It's a formatting, a looking at what occurred, Your Honors, I respectfully submit. And that's why when I look at this, and I use the joke among my team, it's like the Matrix. You think everything is one way, but then unfortunately, it's not what we thought. And that finality that we thought the federal judiciary gave to us in 1973 was not the finality that we have as of June 24, 2022. These are now questions of every legislature that has to consider.
Mr. AG, I'm just trying to understand your argument. You're arguing that the composition of the legislature back in 1990 is not the same as today's, in coming up with legislation. So we have to respect the 1990 legislature's decision. Is that it? But
yes, I would say that because they duly passed, voted upon, and had that law come into effect, had that bill come into effect. It went through the entire Organic Act processes, and it is now law. Our current legislature.
But what about the analogy? I mean, the composition of the Dobbs Supreme Court is different from the Roe Supreme Court. So who do we have to respect? I guess we have to, the Dobbs Supreme Court should respect the Roe Supreme Court composition.
Well, within the judiciary, again, this was an unprecedented event that they actually reversed themselves and said that Roe was wrong and then put a period right after it. They pulled away completely. So what does that say for all those statutes that were passed in light of Roe versus Wade? The legislature did nothing wrong. That when you pull back and look at everything, the legislature did nothing wrong. Those 21 senators at the time that took that act pursuant to the Organic Act, they took a valid act. The people have, for the last 30 years, been deprived of a benefit that we assume the legislature provides to us. That is a harm that just saying that you guys redo it can never be fixed. Also, our current legislature is deadlocked, at least from observing them in the past 12 months. They can't go one way or the other. So this is unlike what was in 1990 when there was a clear statement from the legislature.
Mr. AJ, I have one more question before your time is up. It seems we are obviously in a state of flux in Guam, the medical profession, the health professionals. Is there a stay in abortions, or have there been any abortions performed since Dobbs 2022? And I know that, I think in your brief, you says that prosecution will not occur if abortions were conducted. But what is the current state of affairs on the island?
My understanding is all the public laws that are still in effect are being complied with. Whether or not there's been breaches of the law, I'm not clear. The proposal that I had in light of the Dobbs decision was that 20-134 go into effect, and as the prosecuting authority on Guam, I will not prosecute it if the judiciary in its equitable authority were to call the election that was set forth in Public Law 20-134, which either says that we are going to have no abortions on Guam, or the people will decide that it can continue, that law would not go into effect.
All right, any further questions? All right, Mr. AG, your time is up. Thank you.
Thank you, Your Honors.
Mr. Phillips, on behalf of the legislature in Guahan.
Mr. Chief Justice and Justices. Public Law 134, at the time it was passed, met the constitutional requirements for validity. It also met and it's undisputed, it was validly passed. There's no challenge to the fact that it was validly passed. While the Calvo case is mentioned in the governor's brief, the Calvo case actually dealt with whether a law was validly passed. That's a separate case. And so you're dealing with a situation where there's an evolving court, but there's no allegation that it was invalidly passed. So the question is, well, if it was invalid at the time, why was it invalid? It's invalid because a court said it was invalid, not because the Constitution. So it's consistent with the Constitution. And don't get me wrong, I admit that I'm able to say that today because of the Dobbs decision. The Dobbs decision will go away. I mean, Roe v. Wade went away. I think that's safe to say. That's just the way history works. But today, Senator Arriola and the legislature and Governor Addo were correct. And so the question is, taking that into account, is this court now going to be the venue where somebody that disagrees with the law, instead of going to the legislature and changing it, or there's a possibility of the referendum going through? We leave that to the court.
But the governor argues that we should examine the constitutionality of the law in 1990 at the time the law was passed, not examine it 50 years later.
Your Chief Justice, there's nothing wrong with that at all. It's the consequence of that examination that concerns the legislature, because the legislature is very clear not to take sides. And my comments are not intended. I'm intentionally trying not to take sides. The legislature, without the ability to enact legislation, would never be able to be where they are today, where they have a law that's consistent with Dobbs. But very few times, in fact, the last I checked, 75% of the cases that the Supreme Court of the United States takes are because of conflicts among the circuits. And a large portion of those come from the conflicts with regard to interpretation of legislative actions. So how would, it could be anyway, any case, the insular cases, it could be Brown versus Board of Education, anything that the legislature decides, those are wrong. Let's enact. It's not a trigger law, that makes specific provision for the passage of the issue by a court, a Supreme Court likely, of a case that now makes their legislation legal. That's a trigger law. So
let's go back to the merits of this case. Well, I just don't understand your statement that I don't want to take sides. I mean, what this case is about is whether or not the Guam legislature had the power to pass Public Law 120-134 in 1990 at the time that the law was challenged.
Yes, and it did.
And so the governor says that the legislature didn't have the power to pass an unconstitutional statute because the law of the land was Roe v. Wade at the time, which provided a woman's right to privacy and the right to an abortion. And the Attorney General is saying that statute was a valid statute at the time it was passed. And so the legislature doesn't wish to take a position whether it had the power or not to pass that.
No, Your Honor, Justice, that's my mistake. I misspoke. Whether or not the act that's before the court today is valid There are certain portions of it that maybe need to be cut off.
But
That portion,
that's not
they're
the
not.
issue. That's not the issue.
No, the issues then were very clear. They had the power to act. It was not ultra virus. And there's nothing wrong with the legislature passing a law that at that time, a court. Now, there may be a debate as to what is the law of the land. Is it the court or the Constitution? And I may be mistaken. I thought the
It's
Constitution is the law of the land, and they were correct. And I don't think that that's necessary, though, because, Your Honor, there's no other process for an island like Guam. This court can't, and the governor can't. It's the legislature. They pass a law that is at that point in time not necessarily looking very good when it goes before courts. And so the question is, well, surprise, the court upheld it. How would that ever happen? They would never have a chance. Everything just freezes in time. And that can't be, that's not the way the system's designed. The governor, justice is elected. In fact, the AG is elected, but the legislature is elected. And through those elections, these appointments come to the courts. And so it's a revolving circle. Now, I know we would all prefer to not wear the label that we're political, but we all are, because of the fact that the president in the states and the governor here makes those appointments. It's just a natural course. When you cut off a portion of that circle and you don't allow that full circle to take place, then you've really, I believe, with all due respect, Justice, really infringed on the separation of powers, because they are allowed. This court's allowed to get it wrong. What if there was a same, because it's not in the Organic Act. There's no ultravirus. There's no void ab initio in the Organic Act. It's a conclusion that the governor's drawing in order to win a case. But
Well,
if
the Organic Act does limit the legislative power to only those rightful subjects not inconsistent with the
right.
provisions of the Organic Act and the laws.
And that language is there, Justice, and it's aspirational. And while I submit, I don't remember the case. I think, Justice, you authored it, that had a footnote that really talked about the hammer clause. If you don't have a hammer clause, then it's aspirational. And there's no hammer clause here, meaning that it's a goal, it's aspirational. But guess what? If you get it wrong, it's going to be overturned.
Mr. Phillips, within doctrines that have, that has existed from time immemorial. And so if, as the Chief Justice points out, the legislature passes a law that's inconsistent with the Organic Act, then there is a clear doctrine that it may be stricken, and it may be held to be inorganic. And so I'm not understanding.
No, that's not correct. It can be enjoined. And everybody uses these words interchangeably. That's not stricken. I've been part of commissions where you go and you look at some laws that go back still in the books.
It's stricken from the standpoint that it cannot be enforced.
It's enjoined. It's not stricken. The courts do not have the authority to go into the books and erase these
Well,
laws.
of course not. That's not what we're doing when we strike down a law. We are saying that then the Attorney General may not go and enforce that law.
That's correct. And the Supreme Court can overrule you.
I fully understand that.
And that meant that the law was in existence.
But in reference to if a time period has passed and a writ of cert has not been filed, then a law that this court says is unconstitutional then cannot be enforced.
Well, Your Honor, Justice, as you remember, probably better than me, the case, I believe it was 13th Guam. No, it wasn't 13th Guam legislature. It was Ramsey v. Choco, where without doubt on my part, the legislature passed an inorganic act. The courts held so, but at the same time ruled that, hey, Congress didn't overrule this. They had the opportunity to do it. So we're going to deem it valid. But without doubt, when the legislature passed that, it was inorganic. They were grabbing hold of our tax system. And that's what we have today. The qualifying certificate's still there. It's maybe an anomaly, but it's an example of the fact that the bill did pass. again, Justice, you're more familiar than this than I am, but I also have some familiarity with the issue of whether or not, and this was the 13th Guam legislature versus Medallo, where a governor says, well, you failed to pass a bill and have it enacted, and therefore the budget rolls over. And the legislature said, no, we passed the bill. You just didn't sign it. And so there is no rollover budget. And while I may be incorrect with the conclusion, I'm not incorrect with regard to what the dispute was. But of course, the bill had to pass in order for that to be entertained. This is novel, saying that they can't even pass. There's no sanction. You can't get an injunction against them for doing it like you would if that were the case anywhere else. If I have a piece of property and you rule, you're not allowed to be on that piece of property, I can get an injunction. Can we get an injunction against the legislature from passing inorganic, which will be determined by a court that's temporary, an inorganic statute? I respectfully say we can't, Your Honor. That's the way it works.
And I fully agree. We respect the roles of each branch of government, and we're not going to preempt them prior to passing a law. But when the law is passed, it's challenged in courts. That's the opportunity in which we can address the arguments that's before us.
And that's where the power, respectfully, justices, is limited to enjoining the executive or really anybody from taking any action on that law. And that injunction, it's kind of like a lifetime warranty that a corporation gives. That lifetime warranty is only as good as that corporation's there. And so
yeah, but can't we, in the process of enjoining it, also declare that the law is void ab initio?
well, you can, Your Honor. In fact, you can say anything, but it would be respectfully disingenuous because it's not. There'll be another court here that says the opposite, and we know it. There'll be, you've had the Warren Court, the Berger Court, the Rehnquist Court, the Roberts Court, and they're all different. You have to respect them. And to say though that no, there's a, I think Texas has the 1901 statute or somewhere near there, and there's another state that's going through the same thing. And those statutes are being judged on their merits, not any allegation that the legislature could not pass it. I respectfully suggest if there was such a rule, it would be in the Organic Act. Then I think it's debatable. But right now, it's clearly, as you pointed out, Chief Justice, you didn't say it's aspirational, but you pointed to language that in any other statutory interpretation, I suggest we would find that aspirational because there's no hammer clause. There's no, and if you do, right? There's none of that. And that's what we look for in statutory interpretation when we're dealing with other matters. But
what if the legislature did pass a law that was inconsistent with the laws of the United States applicable one? Let's say they made a decision that they were going to separate students from the FSM with regular students and force them to go to different schools. Are you saying that we can't strike that law down as being void ab initio?
As the term is used, it's become a term of art. But what is being asked that's different here today, Justice, is for you to look at that literally. And so the way I look at that is from the day you've passed that, there's nothing you can do with it. Absolutely nothing. But we have, and it's probably been erased by now, we have laws on the books that are clearly unconstitutional that nobody enforces. Texas for a long time had the noose, right? But nobody could enforce that. And so they just left it on the books. And there's other laws on the books across the states that nobody touches because they're unconstitutional.
We're not talking about, going in and either preventing the legislature from passing the law or striking the law from the books. We're talking about declaring that the law cannot be enforced.
Oh, no, absolutely. And that's really what I think today's hearing should have been about. I mean, Justice Carblito made it very clear to me, and he's correct. What the court invited argument on is really not that. And that's an interesting question because both sides have good arguments. And we're not taking a position on that. And that's really what I should have said, Justice Carblito, to make it clear. But no, on the issue of whether it's passed and whether it's duly passed, really are the same. And in this case, I don't believe either one is disputed. It's passed. The question is, Well, after it's passed, can we retroactively go back and say it doesn't exist? And that's a game that I think while a party may say, hey, this is one way we can win a case, that's not the way. There's other ways. And I do want to make sure, because Attorney Anita Arreola raised a very interesting argument regarding the fact that the referendum has not taken place. And so there's a consequence to that of some sort. And I want to make sure, again, the legislature, I think General Moylan pointed out, they're not taking a position on anything of the substance, but they are united in saying that they can pass those laws, whether they get them right or not. That's in your court. And I don't think anybody is thinking to not follow the rule. But from the trial court on, once a court rules, people can be innocent and get in trouble. They decide, well, I'm innocent, so I'll run away. You can't run away until that's overturned. You follow it, and it's the same here. But it's very different to say that the reason a party is going to win is because there's no prohibition. Oh, it's very clear. It's right there. Now, that doesn't mean that you feel that it's valid today, but that's not why we're here, right? We're here to determine whether it's void ab initio or an ultra virus act. Neither one are mentioned, so there's no hammer clause. So the question is that workable in our system? And we wouldn't be here today because it's void ab initio, as the slang goes. So there's no law for us to discuss today. Of course there is. And there always will be, because the legislature is entitled. Senator Arreola and everybody, I believe, was unanimous, and Governor Ader, were entitled to pass a law that one day, maybe even a long time from when they passed it, they had their views of the Constitution, and one day, in their minds, they're going to be validated. Dobbs came, and that's it. And those that are on the other side just have to accept that it's Dobbs, and like I'm sure the conservatives did in the 60s, they said, we're going to have our day. And they now have their day.
Mr. Phillips, just in a nutshell. So your answer to the governor's question of whether the legislature can pass a non-constitutional law is yes.
Absolutely. Yeah.
All right.
And that doesn't mean, Justice Manglone, that it goes into effect or has any effect, but they are entitled to do that, just as you are entitled to write an opinion that is far off base at this moment, maybe one day validated, and have it overturned by the Supreme Court of the United States. Nobody's going to say that your opinion doesn't exist from the beginning, or that you participated in an ultra virus act. Of course not. That's your job. You write an opinion, and nobody's saying that you were improperly appointed or whatever the requirements might be. Nobody's challenging that. They challenge your opinion. And that's what we do in our system, is we challenge the act, not the behavior of the legislature, but the act itself that came out of it, which may only last one day.
All right, Mr. Phillips, thank you. Any further questions?
Thank you.
right.
Thank you, Justice.
Mr. Huseman, on behalf of Amicus Curiae.
Morning, Your Honors. May it please the court. Mr. Klitsky filed his amicus brief on one issue, jurisdiction. The governor brought the declaratory judgment action under 7 GCA 4104, and that statute expands this court's jurisdiction to allow a court to hear cases that are not, or to hear an action that is not a case or controversy. More than 20 years ago, in the Gutierrez case, this court held that the Organic Act allows the Organic Act allows the legislature to expand this court's jurisdiction. Yet recently, this court held the opposite, that the legislature does not have the power to expand this court's legislation beyond a case or controversy, as it's defined under Article 3 of the United States Constitution.
I think you acknowledge that the airport case provides no textual support in the Organic Act for the court's pronounced constitutional standing requirement and doesn't have an analysis on why the court can't remove why the legislature can't remove the court's self-imposed standing requirements. And didn't the court hear a 4104 case post-airport? So doesn't that suggest that we recognize there can be exceptions to that policy?
Well, it depends on one, if anyone raised it. And the problem with this constitutional rule is when you have these 4104, these these certified questions, these declaratory judgment actions, they're distinctly usually between the two branches of government fighting about an important issue between the two branches of government. They want that issue settled. They're not going to raise standing generally. They want that issue settled. In applying that same standard, a case or controversy, to a bunch of other cases in Guam where the legislature has broadened standing, that becomes a problem because the governor's bureaucracy often comes into court and says, oh, by the way, there's not an injury here. And every time they do that, and I've been in front of this court now with 3 different clients on 3 different issues, or not 3 different issues, 3 different clients on the same issue, with the bureaucracy, specifically the governor's bureaucracy, coming in and saying, no, there's not really an injury, so there's no standing. And so from that standpoint, the court has announced a constitutional rule. And if it's a constitutional rule, I don't disagree with anything the counsel for my friend from the governor's office said, that there are states that relax standing, and the courts often recognize that. This court, however, has announced a constitutional rule, and the constitutional rule, those aren't flexible. They don't bend. They're applied evenly. And so when the governor comes in and says, well, you can bend the rule for me, her bureaucracy does not say you can bend the rule for them. They actually want it rigorously enforced.
I mean, you raise very good points that caused me to reflect a lot on this in terms of the principles that are seemingly in conflict. But, Ms. Travis did point out that, and it rings in my mind that the 4104 statute is a unique statute. Number one, there are limitations. It's only the governor and the legislature that can bring these type of actions before this court. There are standards that need to be satisfied before jurisdiction is invoked in reference to great public purpose. Going through the regular process will cause undue delay, and the other provisions. So it's a unique statute that raises only certain points that leaders in government can bring before this court. So I think the suggestion, and when you look at other jurisdictions, and they also have constitutional standing in terms of the 3-part test, there doesn't seem to be any hesitation for the court to invoke its power and provide an exception in these unique circumstances, but not dilute the requirements of not in other circumstances in issuing what seem to be advisory opinions. So why would not that be something for this jurisdiction to consider?
I don't disagree with anything the court just said. And my disagreement with the court would be with 5 paragraphs in the airport case. And I don't think there's any problem with that. Save this. The court has announced that it's a constitutional rule and that the legislature can't remove it, which means this court can't remove it either. This comes down to a difference between whether it's prudential, whether the case and controversy requirement is prudential, or whether it's constitutional. If it's prudential,
well, I don't think that we're going to be removing it. I think we just need to tether the principle in which we announce that in our jurisdiction, having a test that provides a case or controversy, because that is maybe the best way for us to arrive at a resolution when you have competing parties who are injured and not just raising academic questions, that it would be meaningful. So if we were to base it on the principle that the three branches of government should respect their various duties and responsibilities and impose a restraint on ourselves that only cases that raises a case or controversy type setting should come before us. But there are certain circumstances where, and it's not necessarily the legislature's pronouncement, it's our in furtherance of staying within our lane and actually providing our authority that we're called upon in the Organic Act, and that is the judicial branch to interpret the laws of Guam, that we do that on based on some principle.
Well, and I take no quarrel with the idea that case and controversy cannot be used. I would respectfully quarrel with the court when it says the legislature doesn't define the court's jurisdiction. So if it's not a constitutional rule and it isn't applied to everybody and everyone doesn't have to follow it, then respectfully, what I've always argued for this court is that the legislature controls and you follow the statute as the legislature provides. And that's an easy answer for this court. It would have jurisdiction in this case. It would have jurisdiction in the other cases. What I do argue against is what this idea that the court can say, well, the legislature doesn't control, we control. And then we control what we think is important and we will waive.
I think that's too broad. That's way too broad, Mr. Huseman. And the language is in the Organic Act that the legislature can specify what is brought before this court. It's not written out of the books by us saying that in addition, there must be these justiciable controversy that come with a cause of action specified by the legislature.
And I don't, again, I think we're actually might be talking past each other. I don't disagree that the legislature can authorize a cause of action, and if the litigant can satisfy that cause of action, then it works. What I do disagree with is when the court puts other constraints on top of what the legislature did, and call it a constitutional rule. That is the only real difference here, because if the court is calling it a constitutional rule, and I take the court's point when it says that this is about separation of powers, but that doesn't help here, because what usually happens in when we're asking about a case or controversy is there an injury? Does the plaintiff have an actual injury? Is this case right? Is that injury traceable to an actual defendant? And is the case moot yet? Is there a remedy provided by this court against the defendant that flows, right? And in this case, none of those safeguards apply, because this isn't really a case between, as we've seen, the legislature and the governor. This is a case between the governor and her attorney general, and a dispute they're having about a litigation strategy in a different case. And the remedy that the governor has asked for is to take power away from a co-equal branch of government, and is asking this court to take that power. So the court isn't staying in its lane. It's being a referee about the powers of a co-equal branch of government.
But the Organic Act provides that the court has jurisdiction over original jurisdiction as the laws of Guam may provide, and the legislature has enacted 4104.
Yes.
And so that appears to give us jurisdiction as the laws of Guam provide.
And I would I would concede that immediately. And what I would say though, is that if that is the court's ruling, then it should go back, and I've made this argument before, that the airport case announces a constitutional rule. A constitutional rule means something. What I would say is the 5 paragraphs that I've pointed out in the airport case are dicta. They don't, if the court is saying this legislature can broaden standing, then it isn't a constitutional rule because the legislature can broaden standing. In that case, the court should just harmonize its opinions. Go back to the Gutierrez case.
But I think we would not be not in harmony if we say that there are exceptions to that. And as Ms. Travis points out, there's taxpayer lawsuits that also have its own issues with constitutional standing. There are great public importance cases that also may not satisfy their injury in fact test. There are jurisdictions that clearly recognize that, and although they do adopt the constitutional standing requirements, there are certain cases that because of their unique nature that the court can step out, and not because the legislature prescribes it, because the court within its own principles say in order for it to honor its position as a third branch of government, will address these issues, not because the legislature prescribes it, but it's because we have a certain role that we play in our community.
I don't disagree that the court has a certain role. I would respectfully say that what the court has pointed out to me just then is not the doctrine of why the United States Supreme Court requires a case in controversy. It's the exact opposite. Even if it is important.
And as we pointed out, we're not constrained to adopt the reasons why Article 3 is recognized within the U.S. Constitution.
No, and my briefing and every time I've been before this court on this issue, my briefing has been extremely consistent, which is Article 3 does not bind this court. There is no case of controversy requirement. And
so it's not an irreducible constitutional minimum, but instead prudential self-restraint by the court in its determination.
Exactly, Your Honor. And the reason we've been here before is because the bureaucracy does come in and says irreducible minimum and says there's been no injury and we need this case dismissed. And what I'm asking for, what Mr. Kliske is asking for, is for the court to make clear to the bureaucracy that it will hear cases regardless of injury if the legislature has provided.
I mean, we have done that in the quarantine case. We did that in the Leon Guerrero case, where we recognize that the taxpayer statute survives the airport case because of the legislature's creation of an injury in fact.
And so then the only question here, if the court is saying that this isn't an irreducible minimum and that it can honor the legislature's choice to broaden standing, is whether the court should or not get involved in this case.
I don't know necessarily the legislature is broadened. I mean, what I understand the Chief Justice is stating, it is prescribed the injury and that there is actually an injury in those circumstances. In this particular case, as you will note, I asked Ms. Travis the questions, what is the injury? And there is none that has been articulated.
Sure.
But that's not the end of the analysis in my mind.
Well, no, and I think my briefing is clear on this. Mr. Klitske's briefing is clear on this, that it isn't. If the court isn't applying a constitutional rule, then it's the statutory rule. And I don't deny that this case fits the statutory rule. What I would deny is that this case meets any kind of case or controversy requirement. So if the case does meet the statutory requirements and the court is willing to look at it, that's complete within the court's power, and I think it's appropriate. Now,
so, Mr. Hughesman, you're saying that if we do invoke, if we go through the 4014 analysis, we should just stop with the 2 factors of public importance and undue delay and not require an additional step of constitutional standing? Is that what you're fine with that?
Well, I don't think if the court requires constitutional standing in this case, there's no way to satisfy constitutional standing. That would be the point. It's utterly impossible. That would be the answer. You can't add something onto the statute. The statute reads the way it does, and you wouldn't put on prudential concerns onto a statute, because then you're infringing on your co-equal branches of government. The question then, this is still this isn't a mandatory statute. This is a statute that authorizes you to do it, and you have a choice. This court has a choice, and Mr. Klitsky would urge the court not to get involved in this case for some extremely important reasons.
But I'm not at this point conceding that just because the legislature prescribes a mechanism in which to come into this court, that number one, it doesn't provide the injury or that an injury need not be shown in addition to what the legislature prescribes. All I'm saying is that there are certain unique circumstances in which we may be able to step out of that without necessarily conceding that it is a statutory provision that provides for access to the courts.
And I would say this, and I've said this before. I know you weren't on the panel when I said it before. I maintain this. There's a difference between prudential and constitutional standing, even though they're the same thing. Basically, they're the same test. Prudential standing is this court's decision or this court's desire to avoid stepping on the other branches of government, but it can waive because there are prudential concerns. Constitutional standing cannot be waived. So whether this court decides to waive it on an important issue or whether the legislature waived it on an important issue is to Mr. Klitsky and to myself, I would say, immaterial. It's whether or not it's constitutional and can be moved or not. And if it can't be moved, then there's some issues. But if it can be, then that's the court's choice. But in this case, assuming the court does take jurisdiction, the court should not issue an opinion in this case. This is not a normal declaratory judgment action, the way that they're generally understood historically on this island. Generally, the legislative branch and the executive branch have gotten in a fight about the requirements to pass a law, what constitutes indebtedness, things of that nature, where the two branches are fighting. Here, this is an intra-executive agency fight, where the remedy that the governor is asking for is to say that the legislature lacks plenary power and is asking this court to step on the legislature's plenary power and to go back in time and basically erase a law. Bad facts make bad law. There are all kinds of unknown constitutional harms that are available to this court and can damage. These aren't our institutions. We are moving through them.
But you know, although the legislature has come into this court and said, we're not taking sides, Mr. Phillips articulated that the legislature had the power to pass the statute, and that is the issue that the governor is bringing before us. Did the legislature at the time Roe v. Wade was in existence have the power to pass a statute inconsistent with Roe v. Wade?
And this is why I
So it's not an academic question.
I don't think it's an academic question. What I think is that it's a very complicated question, because the legislature is not an agency of Guam. It is the sovereign. It is intended to be the most powerful branch. It is the first branch under our Organic Act.
And this court has never in the history in which I have been on this court treated the legislature with any less deference.
No, and
we have provided it the greatest respect in reference to the powers that it has.
And I believe that is the case. But as I said, we are moving through these institutions, and there is a corollary to if the legislature doesn't have the power to act. Because if it doesn't have the power to act on Guam, there is a way to confine not just courts and not just agencies to their jurisdiction. That is a writ. And you can get a writ when there's a threatened act of exceeding the jurisdiction. And I know the court has already mentioned in argument today that, you can't get a writ against the legislature. But then the question becomes, why not? If the legislature is acting outside of its authority, And again, I think the legislature has plenary authority. And it's only after they pass the law that this court can say what the law is. But saying that the legislature lacks plenary authority has consequences that we can't know today. There's only been, I mean, there's been a lot of good briefing in this case, but there are no facts. There's a reason why declaratory judgments, the court should be careful on these. And it's when we're making decisions that will have ramifications in the future that we do not necessarily understand what those ramifications are. And right now there is a parallel proceeding. It's before the Ninth Circuit. It will answer all of these questions. And at that time, if the Ninth Circuit wants to send a certified question, have them come down, certify the question. Do not get involved now if you can avoid it. Save, keep your powder dry, protect your institution, protect the people's institution, the legislature. Let the politicians fight. You do not need to get involved right now. I know I'm way over on my time. I would ask that Mr. Klitze would ask that the court harmonize its case law, decline to exercise jurisdiction over this case, and let the politicians fight. Thank you, Your Honors.
All right, thank you. Ms. Ariola?
Mr. Chief Justice, may it please the court. Not a single person here today has disputed, nor could they, that Roe versus Wade was the law of the United States applicable to Guam when Public Law 2134, the abortion ban, was passed by the Guam legislature. It is undisputed that when Public Law 2134 was passed, the pre-viability abortion provisions violated Roe versus Wade and the Due Process Clause of the 14th Amendment. It is further undisputed that the law's solicitation provisions violated the First Amendment. The issue in this case is purely one of organicity. This court has established a clear and consistent body of law, recognizing that the Organic Act limits the legislature's authority to pass laws only to, quote, subjects of legislation not inconsistent with the provisions in the Organic Act and the laws of the United States applicable to Guam, end quote. The court has not hesitated to find that the legislature exceeds its power when it enacts statutes in violation of the limitations imposed by the Organic Act, and that such statutes are inorganic and void. We have shown in our brief that it is not just this court, but the federal courts have also consistently invalidated statutes passed by the Guam legislature in excess of its legislative powers under the Organic Act. And we have also shown that cases construing the revised Organic Act applicable to the Virgin Islands, which is very similar to Guam's Organic Act, have invalidated statutes passed by the Virgin Islands legislature that are inconsistent with the laws of the United States made applicable to the Virgin Islands. Given all of these authorities, particularly the ones from this court, which are consistent in their holdings, the Guam legislature lacked authority to enact the abortion ban under Section 1423 of the Organic Act, and its passage was an inorganic, ultra-vires act that exceeded the legislature's authority. I want to comment on the argument of the Attorney General and the Guam legislature that the legislature would never have a chance to pass laws if this court decided that Public Law 2134 was null and void and in violation of the Organic Act. Every senator on Guam, when they take an oath of office, every person who is elected to the Guam legislature knows or should know the source of their legislative power. They know or should know that under the Organic Act, their power is constrained. And as this court has held, the outer limits of the Organic Act are what constrain the Guam legislature's power. And so to say that the legislature would never have a chance to pass laws because of this court's decision goes too far. That would never happen. The Guam legislature knows what its source of authority is, and it knows what its power is. Certainly, this court will decide ultimately the test of whether or not those laws are inorganic or null and void, but it would not have any kind of a constraining or limiting effect on the Guam legislature. I do also want to address very briefly the standing issue that's been raised by amicus Robert Klitsky and by some of the other parties in this case. I would suggest that the court not take the bait that has been dangled in front of you by Amicus Curiae Robert Klitsky. And that is for the court to either overrule or reconsider its decision in the airport case, the Leon Guerrero case, and the Hamlani case. Amicus Curiae Klitsky has taken one sentence from the airport case and turned it into a principle of law that somehow is deficient. But the court's decision in the airport case and in subsequent decisions makes it very clear what that principle of law is based upon. That there is an issue of constitutional standing that may be imparted and conferred on the standing of parties by the Guam legislature, and that also imparts an injury in fact or a concrete injury in lieu of what is actually required in the constitutional standing cases. That is not a new principle. That is something that has been decided by the United States Supreme Court. It has been decided by other courts. And this court actually referred in footnote 4 in the airport case to 7 GCA section 4104, the very statute on which Imagahaga has filed her petition.
I think, Ms. Ariola, that Mr. Huseman's qualification is not necessarily that there is this test that may exist and that we adopt it, but that it is not satisfied in this case in that there is no can never be any showing by the governor of any injury in fact, as that provision is understood to be in this particular case, that the governor, because of the injunction that currently exists, there is no threat that that statute is going to be enforced tomorrow. And I think that's the argument that Mr. Huseman is stating, that if we're going to continue with the Article 3 standing requirement, and that's a minimum requirement, that it's not satisfied in this case.
Except that there is nothing in our laws that requires the governor to stay in that case. And she has the ability to come before this court to get a ruling from this court about what Public Law 2134 is and what it threatens to do, particularly since the Attorney General has stated that he wants to try to revive that law. And we've heard that today. And so when you talk about constitutional standing,
and I'm just, I know your time is limited. That goes to whether that not that there is a concrete injury and the analysis that all go into that. But my inquiry is that even if there is no such a showing, can this court step out and still recognize a great public importance doctrine that will allow us to entertain these type of cases without this concrete showing of injury?
well, Your Honor, I would disagree a little bit with your question only because I think that there is a concrete injury in this case.
Which is?
And that concrete injury is that we have Imagahaga, who is the chief executive officer of the government of Guam and who is responsible for executing the laws faithfully in Guam.
Yeah.
She cannot do that if she does not know which law applies. And we have an attorney general who's given an opinion and who has said that Public Law 2134 is revived due to Dobbs, and therefore there's a conflict in the law.
There is nothing that can be done to back that up to allow him to go forward and implement that law. There is an injunction, and there is no threat on the governor that if she was to in some way not act in conformance with the injunction, that she'll be at risk of violating any law.
That injunction is only as good and as long as it holds. And
I fully recognize that, but that's what we talk about,
I
concrete
understand.
analysis, and that is something that may happen. But does that satisfy the injury in fact analysis? And based on my understanding, it does not.
Well, Your Honor, I would respectfully disagree, primarily because it is this court's prerogative and this court's obligation to say what Guam law is. It is not the district court's duty, and it's not the
I
Ninth
fully agree
Circuit's.
with that. You're not
And
going
it's
to have
not-
any qualms with me there.
Right, and it's not the Ninth Circuit's decision to decide what the law in Guam is. And so I had always thought that the district court would, when it got to the merits, reach out to this court to find out what is your interpretation.
It may
of
still
public
do.
law. And they may still do it, exactly. And because of that, I believe that there is still a concrete injury and an injury in fact, because we still do not have the benefit of this court's interpretation of the law, which is what should apply in this case and in the federal courts.
Yeah, but that issue is not before this court today.
It is.
We did not accept the question number one in the petition.
Yes, but you did accept question number 2, which is whether or not Public Law 2134 was passed validly and is inorganic, or was inorganic at the time that it was passed. It may not be the same question, but frankly, it leads to the same result, which is Public Law 2134 unconstitutional, inorganic, or is it capable of revival, as the Attorney General and the legislature seem to be saying? And that's for this court to decide, not for the federal courts to decide. And that's where I, kind of part ways a little bit with you in saying that there is a concrete injury. There is an injury in fact. And that's why we have section 4104, so that the governor, Imaga Haga, the Guam legislature can come before this court and say, we don't know where to go. We need your guidance. You're the only ones who can interpret.
So
the organic.
I fully, but I think what you're saying is there is a threat of an injury.
Absolutely. Well, there is a threat of an injury, but there's a concrete injury as well, because, Justice Manglonia asked an earlier question. What's the status of the law in Guam? Can anyone here in the court tell me that? Is the 1978 abortion law still valid? Is Public Law 2134 revived and in effect? Not many people would know that. Even the Guam legislature doesn't seem to know what that law is. It's not just a threat of concrete injury, it's an actual concrete injury. What law applies? And Imaga Haga needs to know what law applies in order to execute the laws faithfully according to her duty.
But isn't the response is that Public Law 2134 cannot be enforced today?
It cannot be enforced today. It could be enforced tomorrow.
But then it's
It
not
could be-
concrete.
It is concrete.
Because you're saying it may be, it may be.
It could be enforced tomorrow. It could be enforced today. It could be enforced at any particular time. When, for example, the Ninth Circuit says, that we're going to reverse, we're going to send it back to the district court, because of the procedural issues that the Attorney General has raised. What we
Then
need
at that
here,
time, it may be particularized. But as we sit here today, we can't say that
but Your Honor, the
because we
court-
don't know how they're going to rule.
except that we do know that there is an inconsistency and an inherent difficulty of knowing which law applies now. When the chief enforcer, the chief legal officer of the government of Guam is saying that Public Law 2134 is revived and the governor is saying no. And that is an injury because the people of Guam don't know what law applies. And that's why all of us are here today to find out what exactly is the state of the law here in Guam with regards to abortion. And that is why we are arguing, my clients, the Amicus Curiae, who probably have the most direct interest in this law, are arguing to find out what is the law here in Guam. Alternatively, Your Honors, we submit that the referendum provision in the law was a condition precedent that prevents the law from being revived. We are the only ones who have raised this issue. The plain language of Section 7A of the law evidences the legislature's intent for the abortion ban to be in effect only until the referendum was held. Depending on the results of the referendum, the abortion ban would either continue in effect or would be, in the words of the statute, quote, repealed in its entirety, end quote. The referendum was never held because the law was enjoined. Therefore, even apart from its inorganicity, because the referendum was a condition precedent which never materialized, the abortion ban is therefore null. The Amicus Curiae, my clients, doctors, individuals, and organizations who are committed to providing abortions and access to reproductive health care in Guam, support the petition of Imagat Haga and respectfully request that the court answer question 2 presented in her petition in the affirmative. Was the passage of the ban in 1990 an ultra vires act because it exceeded the Guam legislature's authority under the Organic Act? Otherwise, we request that the court find that because the referendum was a condition precedent which never occurred, the ban is null and of no effect. Finally, alternatively, for the reasons set forth in the governor's brief, Amicus Curiae respectfully requests that question 3 presented in the petition. To the extent the ban is not void, the ban has been impliedly repealed by subsequent legislation the Guam legislature passed regulating abortions on Guam. Unless your honors have any other questions.
No questions. Thank you, Ms. Arreola. Ms. Travis, we're going to give you 4 minutes or.
Your Honor, I believe Mr. Rohr.
Mr. Rohr? That's fine. Yeah, okay. I thought they were splitting.
Mr. Chief Justice, may it please the court. I am not a lawyer and have never argued before an appellate panel before. So in order to make the best use of these few minutes, please allow me to read my remarks. Mr. Chief Justice, my amicus addressed only the question of whether or not the subject law had been repealed by implication. However, after reading the petitioner's consolidated reply, I opt to use these few minutes to address the petitioner's other question relative to whether or not the legislature exceeded its Organic Act authority, and from a point of view nobody else seems to have touched on yet. The petitioner argues not only that the legislation is defective, but, quote, that the act of passing the legislation itself was defective. While the legislation would ultimately be held unconstitutional and subsequently inorganic, it appears to me that the legislature at the time was within its Organic Act authority to enact legislation that it believed had a shot. By saying had a shot, I'm referring to a March 16th, 1990 New York Times story, which reads, quote, Senator Arreola said that she drafted the bill as soon as the Supreme Court opened the way for new restrictions. The way for new restrictions is a reference to the court's 1989 decision in Webster versus Reproductive Health Services. Indeed, Senator Arreola did draft her bill as soon as the Supreme Court opened the way for new restrictions. Webster was decided on July 3rd, 1989, and Senator Arreola introduced Bill 848 7 days later on July 10. And quoting from a March 23, 1990 Washington Post story, quote, in the aftermath of last summer's Webster decision, legislators in Guam, like their counterparts in many states, decided to test the scope of Webster by placing restrictions on abortion. One can empathize with Senator Arreola's optimism, given the Webster court finding a crack in Roe, a crack held especially loathsome by none other than Justice Blackmun, the architect of Roe. In his dissent to Webster, Justice Blackmun exclaimed, for today, at least, the law of abortion stands undisturbed, but the signs are evident and very ominous, and a chill wind blows. While we may not get many chill winds in Guam, we do get big ones, and it appears that Typhoon Webster went right through the legislature in 1989 and blew all the way to the Ninth Circuit in 1992. In its 1992 decision, the Ninth Circuit memorializes the fact that Guam enacted Public Law 20-134, not in defiance of Guam's Organic Act, nor even in defiance of Roe, but pursuant to a perceived opportunity under Webster. I hereby quote the Ninth Circuit. Guam contends that Roe has no force after Webster versus Reproductive Health Services. Putting Webster together with non-majority opinions in other cases, and the court goes on to identify those other cases, and then says, from this mix, Guam derives the conclusion that its interest in fetal life can overcome the woman's right to choose whether to have an abortion, and that Guam's act is therefore not unconstitutional on its face. Quote from the Ninth Circuit. Ultimately, of course, the Ninth Circuit found Guam's argument unpersuasive. In fact, one of the Ninth Circuit judges in a later decision related to the same case called the whole matter, quote, laughably easy, and characterized the plaintiff's lawyers as, quote, having reeled in a fat and rather sluggish fish. While I did not find the legislation laughable, I did find it irresponsible. Given that I never dreamt of ever seeing anything like Dobbs in my lifetime, I believe that the constitutional slapdown of Public Law 20-134 would have a chilling effect on future constitutionally permissible abortion regulations in Guam for a long time to come. And for the next 28 years, there were none, leaving so-called Catholic Guam by 2008 the easiest place in the nation to procure an abortion. Nevertheless, while Bell's bill went wide of the hole in Roe, opened by Webster, Webster did present such a hole, and the record shows that Guam took a legislative shot at it. Dobbs will later turn Webster's hole into a bullseye. In summary, the record in this matter demonstrates that the legislature set out to protect unborn life pursuant to Webster, and in doing so, did so legitimately within its Organic Act authority. From that point, it was up to the courts to determine the constitutionality of the law, and thereafter its organicity, and they did. I argue that because the legislation was enacted pursuant to Webster, Public Law 20-134 was not unconstitutional nor inorganic until it was found by the court to be so. Thank you, Mr. Chief Justice.
Thank you, Mr. Orr. You'll have 4 minutes.
Your Honor, I want to start with the inquiry from Justice Carbolito earlier regarding an injury in fact. And while my actual statement earlier with regard to 4104 and whether there's an injury in fact, I actually raised, Your Honor, that in the airport case in footnote 4, the court actually recognized that 4104 in its enactment elevated the injury, the intangible injury that the governor had to that of an injury in fact for purposes of constitutional standing. I'm sorry, for purposes of constitutional standing. So further, so long as the governor met the criteria that was established in 4104, she had an injury in fact for purposes of Article 3 standing.
So, but the question then is, if the legislature can prescribe the injury by statute, does the petitioner still have to show how that injury, how it exists, and in reference to the facts in the case? The legislature may be able to prescribe the class of injury, the type of injury that will allow access through the statute, but is there then but then does that mean that the petitioner then does not show how he or she is personally affected by the statute, by whatever controversy exists?
Your Honor, pursuant to the court's opinion in the Ken Leon Guerrero matter, once the statute actually delineates specific criteria and it's met by the plaintiff, it's no longer necessary for them to demonstrate how it manifests in their personal life. In that case, it was taxpayer standing. If you're a taxpayer, you're a resident of Guam, you're good as long as you're requesting the proper remedy, right? Which was the defect in that case. So likewise here, if the governor demonstrates, all the criteria in a 4104 matter, and I would submit that there actually is, as Ms. Arreola pointed out, there is an analogous requirement in 4104 that speaks to an injury, which is that it has to have an impact on the operations of the executive branch.
Yeah, I would only say that if Mr. Huseman was allowed to then come up and respond, is that that steps out of the constitutional analysis tests, and in reference to the Leon Guerrero case, taxpayer standing, that's been recognized as an exception to the three-part test. Great public importance. There are case laws that say that because of the unique nature of these questions, we're not going to require the constitutional standing test to be satisfied. And so I think what I'm saying is that while constitutional standing may exist in our jurisdiction, and there is an analysis that needs to be satisfied, are there other circumstances that don't satisfy that three-part test that will allow access into the courts?
I agree, Your Honor. And actually, Mr. Huseman, it appears though everyone is on the same page here. The court, Mr. Huseman does discuss this rule as a constitutional rule. It's a constitutional rule for the US that was adopted by Guam. So far, there hasn't really been an explanation of whether or not the Organic Act of Guam, our local constitution, whether or not that provides the same, contains the same text that is of concern.
And maybe this case will give us the opportunity to articulate the basis for that.
Yes, Your Honor. And as I discussed earlier, I do believe that it is in there, that the original jurisdiction of the Supreme Court, the legislature has broader authority to confer jurisdiction there, as opposed to the causes that it's limited to defining for the lower courts.
Let me just ask one question. If we end up addressing and deciding that the law was repealed by implication through the subsequently enacted legislation because they can't be reconciled, do we have to address the ultra virus argument?
Your Honor, I've been thinking about that as well, actually, because the constitutional avoidance doctrine ordinarily allows the court to address the issues that would resolve the matter and avoid the constitutional question. However, due to the nature of this particular action, which is a declaratory relief action, it doesn't appear as though there's a priority that's established in the statute. Certainly there isn't one in the case law. Ordinarily, if this were brought through a regular cause of action, through a lower court, even in the district court, right now, my motion for abstention actually submits to the court that they still have a constitutional issue to resolve there, which is why they should abstain to let this court resolve the other questions with regard to implied repeal. If this court determined that the subsequently passed laws repeal 20-134, then the district court would not need to resolve the remaining constitutional questions. That's an argument that I made in my motion for abstention. However, in this case, because it doesn't appear as though there is a prioritization, there is a recognized doctrine of constitutional avoidance with regard to DEC relief actions, it's difficult to articulate why it would be necessary or even appropriate in this case. Your Honor, the answer to your question is just simply there isn't any authority that speaks to that.
All right. The court has no further questions and will take the matter under advisement and will issue a written decision and will now stand adjourned. Thank you, counsels.